in Arizona, we have two different arms of the family court. And there are family court judges and there are commissioners. And typically commissioners handle orders of protection. And oftentimes our family court judges have nothing to do with those orders of protection. So it's very possible for a person to go in and get an order of protection from a commissioner and prohibit the other parent from seeing the child or children. And the family court judge doesn't even know about it. So a lot of times commissioners are reluctant to give orders of protection, although I do see that happen when there is a family court case. So I want to talk about orders of protection for a minute, because they are good tools. When you feel like you're in danger or threat of physical harm or domestic violence, or you feel like your children are being abused. But the order of protection judge does have to find that the child is in imminent danger. If the judge doesn't find that there is a threat that is imminent to the child or children, then the judge is going to tell you, I don't find an imminent threat. So then the next step is to go to your family court judge. If you go and you try to get an order of protection, if the system is like the system in Arizona, and you can't, you have to go to your family court judge. In order to get a modification of a parenting plan or a custody arrangement, a judge is going to have to find that there's a change in circumstances. And certainly if you find out that your child is a victim of abuse or there's a threat of abuse there, then I would consider that a change in circumstances and something that you could go back to your family court judge and ask for a change or modified parenting plan to supervise visits or something along those lines. Orders of protection are used a lot of the time as tools, though. People use them as tools to prevent another person, the other parent, from seeing the children, just for revenge, just for purposes of being mean. And this is not why orders of protection exist. And so I would strongly caution you, you can see my dog back there, I would strongly recommend that you never do this, that you never try and get an order of protection just to be vengeful, or if your child is in imminent danger, because it could backfire on you. So imminent means that something is about to happen. So imminent, the way I spell it in the family court system, is IMMINENT, imminent. So that means something is about to happen, like the child is at risk of something happening right now or today or tomorrow, like imminently. It's going to happen immediately. Imminent equals immediately. If you are in fear that your child is going to be abused at some point in the future, the judge is probably not going to give you an order of protection. If the child is not in a situation where he's at risk or she's at risk of substantial harm or death, then probably the judge is not going to give you an order of protection. And you're going to have the family court system look at your overall parenting plan and custody plan. Remember, when you go to your family court judge, there are ways of getting expedited relief or accelerated relief. So it may not be as quick as getting an order of protection, which you can get like that, if the judge will give it to you. But if you go to your family court judge and you say, we need to change parenting time, we need to change the custody plan, the legal decision-making plan, and then, usually that takes time. But if you ask your judge for temporary orders, and I have done a video on temporary orders. So a temporary order is an order that's in effect while your case is pending. And when a judge makes a temporary order, the judge is saying, this is what's going to happen while the case is pending. These are the orders that are going to be in place. So if you're afraid, even though the risk may not be imminent to your child, that the child is still at risk, you can ask for temporary orders as part of your overall request to modify custody or parenting time.